Saygıdeğer misafirler, tekrar hoş geldiniz. Uluslararası hukuk açısından 1915 olayları başlıklı ikinci oturumumuza başlıyoruz. Bu oturuma Profesör Doktor Sevgigül Akyılmaz başkanlık edecek ve oturumda Avukat David Saltzman, Hazer Çağan Elbir ve Doktor Deniz Akçay konuşmalarını gerçekleştirecekler. Ben şimdi sözü oturum başkanımız Profesör Doktor Sevgigül Akyılmaz'a bırakıyorum. Buyurun efendim.
Teşekkür ediyorum. Hazirun'u saygıyla selamlıyorum. Uluslararası hukuk açısından 1915 olayları başlıklı ikinci panelimizde 3 değerli konuşmacımız yer almakta. Ayrıca konunun tamamlanması açısından, bir bütünlük teşkil etmesi açısından son dönemde çok gündemde olan mülkiyet meselesi.
In the last period, the ownership issue is very on the forefront, and the cases opened for this reason are added to this session. And with the organizing committee, we reached an agreement, and after 3 distinguished speakers, I will also make a presentation, kind of a presentation. Therefore, I think it would be good to regulate to have such an order. There will be 4 speakers and each will have 15 minutes, and I will expect the presenters to deliver their presentations in 15 minutes, and then if there are any questions, they will be responded, and this session will be concluded after responding those questions. And now, according to the order in the list, I would like to invite Attorney David Saltzman in the first place. He will be speaking about the successor state and the succession of state and moral obligations.
It's your turn, David Saltzman. Please speak now.
Şimdi
herhangi bir sorun mu var?
is there any problem?
Would you like me to begin?
It's your turn, yes.
Okay, great. Thank you very much, Professor Akyılmaz. Let's see here, I'm going to share my screen, so I have a presentation to share with everyone. Okay, can everyone see this? Wonderful. Okay, well, first of all, I would like to thank and congratulate the sponsors and organizers of this event, and I'd like to express my admiration for my co-panelists and other presenters. I have learned quite a lot thus far. When I saw the final program for this conference, I confess that my name looked out of place. After all, I'm neither a historian nor a professor of law. I'm a different sort who deals with World War I. I'm a legal practitioner, a professional advocate. In my practice, I have taken on a number of cases at whose core is the question of whether one can espouse a particular viewpoint in a genuine historical controversy and not suffer for it, whether financially, academically, or professionally. And many times that viewpoint is an unpopular one. My clients have included university students, university professors, a sitting member of the United States Congress, and nonprofit advocacy organizations. And I've had the honor to represent the Republic of Turkey in litigation concerning World War I era events. So history matters deeply to my clients and me. So an empire has died. Who pays for the funeral? In the case of the Ottoman Empire, and especially the events in 1915, we are talking about whether the Republic of Turkey, the state that sits upon the remnant core of the imperial dominions, is presently responsible for the alleged internationally wrongful acts of the Ottoman Empire. Sometimes it could seem as if one's moral compass demands elevating compassion for those who suffered losses during war, above the search for clarity in the historical record and the assignment of legal responsibility. But I would assert that these stand on equal moral footing. Indeed, sincere compassion cannot exist independently of historical accuracy and the application of the rule of law. With that in mind, we begin the legal analysis with the concept of state succession, which can simply be defined as the change or transfer of sovereignty over a certain territory. However, this simple definition is inadequate. A change of sovereignty over how much territory is sufficient for there to be state succession. What rights and obligations, if any, are automatically transferred from the predecessor state to the successor state? Does the successor state succeed to all treaties of the predecessor? How about to its debts? Some terminology has developed to help us make sense of this. In particular, the distinction between a successor state and a continuing state. This is important because the transfer of certain rights and obligations to a successor state has not been the traditional norm, whereas state practice has been developing to make the passage of rights and obligations onto continuing states. The doctrine has its roots in two principles. First is the widespread belief that a state should be held accountable only for its own wrongful acts. Second is the notion that liability does not pass on to one's heirs. These rationales have been criticized as being outdated, and a modern theory has emerged that favors succession to international responsibility, but only for continuing states. And it is, of course, more complicated than that, as continuity and succession can coexist. A predecessor may have multiple successor states, only one of which is recognized as or asserts itself as the continuing state. And one can see how messy this can be, especially in the case of the former Ottoman Empire. If one were to overlay a modern map on a map of the Ottoman Empire at its greatest extent, one would now find all or parts of, by my count, 42 countries, Turkey included. Those who favor imputing all Ottoman responsibilities to the Republic of Turkey continue Turkey the continuing state. For some scholars, the concept of the continuing state simply implies that the identity of the new state is legally indistinguishable from that of the predecessor state. One merely looks at the new state as being the same as the old state, but with a different group governing it, and maybe some modestly adjusted borders. An alternate theory of continuity includes a wider variety of so-called objective and subjective factors in assessing the identity of states. Let's look at past examples to see what factors have played an important role in the continuity determination, as well as what rights and obligations have been deemed transferable to continuing states. I have to say in advance that I don't find either approach very useful, whether the new state theory or the many factors theory. The circumstances of imperial collapse, dissolution, and new state formation are too diverse to allow easy classification, and therefore the adoption of strict rules. In my opinion, each empire is sui generis, that is, one of a kind, and so is an imperial collapse. To use an animal classification as an example, one can neatly sort out a rule to describe a house cat, a tiger, a lynx, a leopard, and a lion. But can you sort out a rule to describe a platypus, an elephant, a rat, and a porpoise? They're all mammals, but finding a rule is a far messier affair. With that in mind, let's look at a few imperial collapses and how they have been treated by law, and perhaps more importantly, how the successor states have treated themselves. Though as many as 6 types of state succession have been identified in the academic literature, I'm going to focus on 2 types that are most relevant to the Republic of Turkey's relationship with the Ottoman Empire: state dissolution and state secession. Dissolution of states describes situations where a state goes extinct and several new states are created in the original territory of the predecessor state. Examples are the dissolution of the Socialist Federal Republic of Yugoslavia and Czechoslovakia. The various examples, both old and new, suggest that in cases of dissolution, there is no general rule of succession of responsibility arising from the wrongs of the predecessor state. There are examples, but no rules. Whenever successor states have succeeded to international responsibility after dissolution of the predecessor, they have done so through voluntary agreement and not under any legal obligation. Secession occurs when one or more new states emerges from a predecessor state, but the predecessor state continues to exist. Thus, when there is secession, there is both a continuing state and a successor state, or perhaps many of them. This would be the traditional analysis for the case of the Ottoman Empire in Turkey. Examples have ascribed the responsibility arising from international wrongful acts of the predecessor state to the continuing state, since it, and not the successor state, has the identity of the predecessor state. Looking at the Austro-Hungarian Empire, Austria considered the breakup of the short-lived Austro-Hungarian Empire at the end of World War I to be a case of dissolution, with Austria, Hungary, Czechoslovakia, Poland, and Yugoslavia emerging as new states. The victorious Allied powers of World War I, on the other hand, agreed that this was a case of secession, with only Austria and Hungary as continuing states, but the other states being successors. In the 1919 Peace Treaty of Saint-Germain, signed between the Allied powers and Austria, Austria said okay, and generally accepted responsibility for losses and damages for quote-unquote as a consequence of war. So even though Austria accepted this responsibility in 1919, by 1926, 7 years later, the Austrian Constitutional Court decided that, except as otherwise provided by a treaty of the country, Austria will no longer be held responsible for the empire's liabilities. Let's look at the USSR. When the Tsarist regime fell, the Soviet Union claimed that it was not the continuing state of Tsarist Russia. Later, the USSR changed its position and accepted continuity with Tsarist Russia, at least with respect to treaties. Moving forward still, the present Russian Federation is most often viewed as a continuation of the USSR, but other scholars believe that it is a new or a successor state. Russia itself has taken a piecemeal approach. In 1992, it entered into a cultural agreement with Germany, in which it reaffirmed an earlier agreement between the Soviet Union and West Germany, itself a state that no longer exists. And in 1997, Russia entered into a settlement with France, whereby it agreed to pay the value of pre-revolutionary Russian bonds that were nationalized by the USSR after the revolution of 1917. As these two examples demonstrate, even as the continuing state of the USSR, Russia entered into these two agreements voluntarily. There was no legal standard by which Russia was obliged to take on these responsibilities, nor any international body that directed Russia to act in a certain way. Moving on to Germany. After the German Reich was defeated in World War II, two countries emerged, the Federal Republic of Germany and the German Democratic Republic, West Germany and East Germany. Unlike Austria, West Germany took the position that it was the continuing state of the German Reich, whereas East Germany viewed that there were two German states as new entities. The international community was divided. France defended the idea that the German Reich ceased to exist in 1945, while the United Kingdom treated West Germany as a continuing state. In 1990, the Treaty on the Establishment of German Unity was signed between the two Germanys, according to which a new state was not created, if you use West Germany's language, and despite what the language suggests, East Germany was integrated into West Germany. Thus, you have some sort of continuity between the West German state before and after unification. This all gets very messy. So the Turkish case. Is it a continuing state or a successor state? As I have noted, the collapse of each empire and the birth or rebirth of new states is unique to its facts. So we must look at history for clues about who should pay for the Ottoman Empire's funeral. Let's start with the fact that the Ottoman Empire's decline was gradual, not precipitous. It lurched through various attempts at reform and rejuvenation through the 18th and 19th century. By World War I, it was deeply in debt and reeling from losses in the Balkan Wars. During the war, Ottoman troops fought on 7 fronts from Iraq to Macedonia. But of course, the ultimate result in 1918 was defeat. The Sultan's government, under great duress, agreed to the Treaty of Sèvres, but it was never implemented, and the rise of the nationalist forces under Mustafa Kemal rendered a new state of affairs. As the war-weary allies departed the theater and demobilized, a Turkish National Assembly governed between April 1920 and the end of the Turkish War of Independence. This was alongside, of course, a remnant Sultan's government in occupied Istanbul. This government concluded treaties such as the Treaty of Moscow, the Treaty of Kars of 1921, and also concluded the Treaty of Ankara in the same year, in which France gave de facto recognition to the nationalist government. The Turkish War of Independence did not conclude until 1923, 5 years after the end of the First World War, with the signing of the Treaty of Lausanne, which carried with it wider recognition of the nationalist government and paved way for the Declaration of the Republic. So the Ottoman Empire's decline was long, and the birth of the Turkish Republic was also a lengthy affair. Indeed, both the nationalist and Sultan's government were present at the London Conference in 1921. So it's worth emphasizing that transformation from empire to republic is hardly a linear process. When discussing Turkey's status as a continuing state or successor state, an important factor to consider is territory. The Republic of Turkey succeeded to a relatively small portion of the territory of the empire. It is important to note, however, that many will consider Turkey a continuing state, despite the substantial loss of territory, because it retained the core of the empire, or have some have put it, the historic homeland of the Turk, Anatolia. This, however, is a shaky foundation upon which to establish a legal obligation. After all, the Turkish Republic did not retain many of the wealthiest parts of the empire, the Balkans, oil-rich northern Iraq, or many other parts of present-day Iraq, numerous islands and islets in the Aegean and the territorial sea surrounding them. At its height, the empire stretched from Austria in the west to the Caspian Sea in the east, from Ukraine in the north to Ethiopia in the south. When the Turkish Republic was formed in 1923, it had within its borders only Anatolia, Istanbul, the Turkish Straits, and a small Thracian hinterland. If what is deemed essential could very well be the wealthiest part of the empire, the Republic of Turkey was not reduced to the essential parts of the old empire. So let us begin to answer our question. Who pays for the Ottoman Empire's funeral? Well, in one sense, Turkey already paid by accepting the loss of these valuable territories. In addition, even though ethnic Turks made up the largest group of the territory of the new Turkish Republic, the Ottoman territories that were lost to other successor states also comprised a significant number of ethnic Turks. A good indicator of this is the population exchanges that took place between the Greeks and Turks and others following the foundation of the Republic, where nearly 2 million people were involved. So, again, who pays? Well, Turkey paid again by having to absorb and resettle a huge influx of new citizens. If we look at a slightly longer period, from 1790 to 1923, 1.9 million Christians and 5 million Muslims were forcibly displaced as the Ottoman Empire crumbled, according to this insightful map by Professor Justin McCarthy.
Mr. Saltzman, 2 minutes remain.
Okay, well, let me move a little bit closer to my conclusion, and I thank you for that kind notice. We have a variety of objective and subjective factors to determine who should pay and who should lose. In other words, whether Turkey is a continuing state or a successor state. But I would conclude that Turkey has no legal obligations as it has met all the obligations that it acceded to when it was formed, both in the Lausanne Treaty and by factors as to what territories did it lose. We can move on then to say that has Turkey itself been judged by others to be a continuing state or a successor state? Right after the war, in 1925, for example, some arbitration said, yes, Turkey is a continuing state, not a successor state, and therefore it owes these obligations. But in truth, Turkey has moved over time to say it's not convenient for me to be a continuing state. I am more of a successor state. So what we end up with is there is really no fixed body of law that requires a state to meet the internationally alleged wrongs and to compensate for them following the end of a war. In other words, it is voluntary. People have tried to create a body of law, and I think all of those attempts to create it has failed. So Turkey, based on its own national interests and as an expression of its own sovereignty, can choose to voluntarily address such allegations in the manner of its choosing at the time of its choosing, really based on these questions for the Turkish people and government to ask, who are we? Whom do others think we are? And how do we end wars so that they do not recur? And indeed, that is the key here. Empires collapse during war. When wars end, you want them to end with finality, and you want those who negotiate those agreements to go into the negotiating room believing that they can end the war forever and not have it reignite when people decide they don't like the terms of settlement. And therefore, it's essential that you have every party there feeling voluntary and sovereign. And that is really the key. We don't need these other factors. Well, I can move on to the questions, and I hope I haven't exceeded my time. Thank you.
It was very informative presentation. Thanks a lot. İlk konuşmacımızdan sonra ki kendisi
After the first speaker, in terms of international justice, it was a debatable subject, and he delivered a very informative presentation, and he talked about actually the objective factors. And now, depending on the program, I will invite the second speaker, Hazelcan Elbir, and from AVIM. He works as an analyst. He talked about the Sasunian case in terms of international relations. And now we will listen a presentation. The floor is yours.
Thank you very much. I prepared my presentation in English since it's an international conference, and let me continue that way, speaking in English. You have 15 minutes. Let me also state beforehand that I have rehearsed my presentation. So it will be around 17 minutes, I can say precisely, and let me say it in advance. Okay, let's then start straight away because we have very limited time. Thank you very much.
I would like to thank the Presidency of the Republic of Turkey Directorate of Communications for inviting me among these distinguished names. It's an honor for me to take part in such a significant conference. Today, I would like to touch upon the latest developments regarding the international relations. When we consider the title of the second panel, the events of 1915 in the light of international law, I'm going to talk about its results in international relations. I'm not a law graduate, but in my opinion, the latest developments are significant for every individual. I'm sure that Mr. Saltzman has more to say about the Sasunian case, but I would like to share my views considering the international relations. These are my points for my presentation: Armenian terrorism, assassination of Kemal Arıkan in Los Angeles, and what are the results of this assassination and the parole of Armenian terrorist Sasunian. The Armenian terrorism has always been a significant issue for Turkey. Turks have been subjected to Armenian terrorism for 3 times in history. The latest phase of these attacks is still in our minds. I'm deeply upset about reminding the unfortunate attacks. More than 30 Turkish diplomats have been martyred. On January 28, 1982, Consul General of the Republic of Turkey in Los Angeles, Kemal Arıkan, was assassinated by the crossfire of 2 terrorists in the morning hours while he is in his vehicle, stopping at traffic lights close to his residence. The Justice Commandos of the Armenian genocide claimed responsibility for the assassination. It is useful to remember the city of Los Angeles and the state of California at that time. One must recall that the terrorist organization that claims responsibility for the attack was connected to the Armenian Revolutionary Federation and was continuing the Tajnak traditions of terrorism. Asala and Justice Commandos are the terrorist organizations that have committed the most acts of terror against Turkish diplomats and their families. So, what was the source of their audacity? The radical nationalist Armenians being so prevalent and effective, especially in California, goes back to 1979 when a politician of Armenian origin named George Dökmejian became the Attorney General of California. Turkmenian was a powerful political figure who presided over the state's prosecutors and police officers. Turkmenian, who was part of the Republican Party, made efforts to become the California governor and joined the elections as a candidate of the Tashnak Party in California. In periods when radical nationalist Armenians were prevalent in the state, a bomb attack was organized against the residence of our Consul General in Los Angeles, Kemal Arıkan, in 1980. Similar attacks were conducted against Turkish associations and agencies afterwards. On November 1981, a bomb attack was also carried out against the ambassador of the Republic of Turkey to Washington, Şükrü Elekdağ, during his visit to the Consul General in Los Angeles. The consulate building of the Republic of Turkey was significantly damaged as a result of the attack. It is known that how Kemal Arıkan emphasized the necessity for taking precautions when asked what it was like to serve in a state where there was a significant Armenian population. Regarding such conditions, the importance of the United Nations Vienna Convention on Diplomatic Relations should come to mind. And you can see the convention. The 29th article of the convention that came into force in 1964 states the person of a diplomatic agent shall be inviolable. He shall not be liable to any form of arrest or detention. The receiving state shall treat him with due respect and shall take all appropriate steps to prevent any attack on his person, freedom, or dignity. The failure in the implementation of this clear stipulation cost the lives of Consul General Kemal Arıkan and the other members of the Turkish Ministry of Foreign Affairs. It's also significant to remind that the parole of Sassounian depended on the approval of California governor. It will be helpful to present a brief history of the demands for Sassounian's release. Release hearings have been brought to the agenda 7 times since 2006. Demands for release were rejected in the hearings in 2006, 2010, 13, 15. A release order was issued in 2017. However, it was turned down by the governor, Jerry Brown. The demand for release was brought to the agenda once again in 2018, but rejected. A release order was also issued in 2019 as well, but it was rejected by California Governor Gavin Newsom on May 25, 2020. Recently, on 24th of February 2021, the Supreme Court of California overturned Governor Newsom's rejection decision. In this context, it is beneficial to draw attention to the explanations by the U.S. attorneys Mr. David Saltzman and Mr. Günay Evinç shared their views in detail on why the terrorist Sassounian must not be released. On March 2021, a very upsetting news report was published. The office of the California Governor, Gavin Newsom, informed the Armenian National Committee of America Western Region that the governor decided to approve of the decision for Hamdik Sassounian's parole. Regarding the subject, the U.S. Secretary of the Antony Blinken stated, "We are disappointed by the expected grant of parole in the state of California of convicted murderer Harry Sassounian. Attacking a diplomat is not only a grave crime against an individual, it's an attack on diplomacy itself. However, it is not sufficient for a powerful politician in the United States administration to only express that he is disappointed and must implement more effective ways against the decision that gives a green light to terrorism and disregards the law." I believe that the release of the terrorist Saltzman, despite knowing that he does not feel remorse and that he has stated that he would do it if he could, warrants a greater reaction than disappointment. Such a release constitutes a risky situation not only for Turkey but for the United States as well. It will be useful to remember who Saltzman is, whose release has pleased Ankara. The remorseless terrorist Hampik Saltzman, the terrorist of the martyred Consul General Kemal Erkan, is being portrayed as a hero by the radical nationalist Armenians in California. In fact, during this long process, a fund directed by the Daşnak Party was established for high sums to be collected as donations for Saltzman. Turkish-American National Steering Committee task co-chair attorney Günay Erinç has emphasized the U.S. judiciary has become politicized and added that the government presenting any reason for the continuation of the conviction would have been sufficient for rejecting parole. In such a case, no one would be able to object to the governor's statements. The governor's statements are essential, even if it is controversial. In this case, there is no controversial statement, and Governor Newsom presented the San Quentin State Prison's report on mental health as a justification document to the court. According to the report, the release of murderer Saltzman will pose a threat to public security. However, it appears that the judge has disregarded such an important piece of evidence. In his statement, U.S. Attorney Günay Erinç highlighted that U.S. Secretary of State Antony Blinken, who expressed that he deeply regrets the Saltzman decision, stated that there is another way to prevent Saltzman's release. Günay Erinç indicated that there is a possibility for Saltzman to be arrested once again right after the implementation of the release decision. Erinç structures this possibility by drawing attention to clause 1116 of Article 18 of the U.S. Criminal Code. According to this article, it is crime to murder a diplomat, and the punishment of the crime is a life sentence. This article being disregarded, Erinç has expressed that Kemal Erkan's family, as well as the Turkish Republic, have struggled since 2013 in acquiring information on the release hearings. In fact, he has explained that seventh hearing in 2019 was learned about only 2 weeks prior to the hearing. It is clear that this stance was displayed in order to pave the way for the prisoner's release. One of the Blinken's statements is that the terrorists who murder U.S. diplomats have received life sentences. He not only expressed that these countries must not release these convicted terrorists, but voiced that they would otherwise be sanctioned in case of a release. France and Greece are two countries which the situation applies. There are convicts who have murdered U.S. diplomats in both countries. The United States, which threatens countries where convicts who have murdered U.S. diplomats are being held, is disregarding its own law and displaying an eagerness to release an international terrorist despite the presence of valid evidence regarding this subject. This signifies that the war on terror discourse amounts to idle words. The United States jurists and high-ranking politicians need to remember that they must be heedful of their own domestic practices while they give messages of democracy, law, and justice to the world. To make such a decision with regards to the ending the conviction, when all the evidence and justification are in favor of the Arkan family and the Republic of Turkey, would mean to marginalize Turkey and to overlook the unlawfulness of the relevant Armenian actors and thus disregard justice, especially in this period when the tensions between the United States and Russia are on the rise. It is not possible to understand why the United States is still defending Armenia, which is a collective security treaty organization member, against a NATO ally. The U.S. support for organizations which openly engage in terrorist organization activities in the south of Turkey, in addition to Sassoonian decision, leads to conviction in public opinion that there is a hostile sentiment against Turkey in United States politics. Considering these developments, if the United States President's statement, which have become customary to be done on April 24, is to be one-sided and pro-Armenian, as they have been until today, dark and difficult days will be unfortunately weighting Turkish and United States relations. Thank you very much for your attention.
Sayın Elvir, teşekkür ediyoruz. 17 dakikada olmadı bu arada. 1 dakika daha erken.
Thank you very much. It's not 17 minutes actually. You finished 1 minute earlier than your previous plan. Thank you very much for very clearly and explaining in a detailed manner a very controversial topic. Let us continue with our third speaker without making any comments on your presentation, because we will later take the questions if we have the time. We will be asking those questions to our speakers, but about the questions, I should say, some questions do not have an addressee. I mean, the participant didn't state who the question is for, so any speaker willing to answer will be free to answer the question. First speaker will be Deniz Akçay, will be speaking about the Armenian claims under the light of international court decisions. Mrs. Akçay, so to be fair, I will give you 16, 17 minutes, just like the previous speakers. I will give you the same time, around 17 minutes. The floor is yours.
Sayın Akçay, sesiniz kapalı görünüyor.
I think you are muted, Ms. Akçay.
Buyurun Sayın Akçay.
Yes, please.
Teşekkür ederim. Her şeyden önce,
Thank you very much.
Cumhurbaşkanlığı ile
Before starting, I would like to thank
düzenlemiş olduğu bu önemli toplantı için
organizing such an important event organized by the Directorate of Communications, and I would like to extend my deepest appreciations to all of you. Now,
yazdığım
I wrote some articles and I made some researches about this issue in the past, and today very important evaluations were made, and in terms of all of these things, these allegations, claims, these claims should be re-evaluated in my perspective. And today, of course, beyond the contributions that were made today, I think new findings and new decisions are available. And there are many important decisions that were taken and in The Hague, and also European Court of Justice, and again international
toplu olarak değerlendirilmesi.
Court of the decisions should be evaluated collectively.
Bu konuda
And in this regard,
üzerinde durmak istediğim bir konu.
I would like to touch upon one subject.
Daha önce de yazdığım bir yazıda bu
I also wrote an article beforehand. First and foremost,
iddiaların
these claims and these allegations actually
yıllar
were shaped in years, in specific years, in certain period.
şeysinde de yani ve olaylara
And
en
again,
yakın olan toplantı, uluslararası toplantı.
the meeting that is closest to the events is SEVR meeting, and they were raised in the agenda in those meetings, but they were never examined in detail, and they were never taken serious in those meetings. And in that meeting,
Evet, o SEV anlaşması.
in SEVR, Treaty of SEVR, which never took into force,
Bazı iddialar ileri
there were some claims, and some claims were put forward, but
gerekçelendirilememişti.
they were not justified.
Genellikle konu
And in general, the subject
iddialar üzerinde durulmuş.
were mostly on the allegations, and it was not very detailed, but a kind of a scattered views, and the claims were raised on that meeting. First, when they joined the Treaty of SEVR, there is a word of genocide, but the most important thing is I find in the meetings, and let's do not forget that the Ottoman as Ottoman Empire, it is not invited, by the way, and it doesn't present its arguments. And which I find important and which I elaborate, there are two issues on which I elaborate. And first of all, is in that meeting, the Armenian volunteers, I call it volunteers, in brackets, in also in the Foreign Legion, they work, they are ready to be included in the war, and they are ready to be engaged in in wars and armed conflicts, they said. And again, there was no such detailed table. They did not present any detailed table in the meeting. And there is something else I would like to touch upon in that SER debate. In the minutes of 700 pages, there was a minute, the minutes of the meeting of 700 pages, and in that, in those minutes, when you look at the content of the minutes, what is mostly focused is not allegations that are attributable to genocide, but to whom Erzurum will be given. For example, it is most important. It is the most important issue, and these 700 pages minutes, and in the 500 and 514 pages, there was a debate. It is written that there was a debate. The Prime Minister of the United Kingdom, and there was also the French group, and the French openly said Erzurum should be given to Armenia. And Curzon said Erzurum should not be given. I mean, it is painful not to give Erzurum to Armenia. And Lloyd George said openly, it is not appropriate to give it to Armenia. It would be unjust to give it to Armenians. And these claims are included in the pages 511, 13, and 14 in the minutes of 700 pages. However, since that period, of course, very many changes took place. And today, by the way, there was another important subject. Within the text, there was something important, and within the text of the treaty, there is no such article which can be attributable to the genocide. Saint-Germain and Versailles treaties, and the massacres, kind of these words, these expressions were used in the text. And of course, it is useful to detail, to work in detail on those issues. And later on, but in recent times, we are not in that position anymore, especially Serbia and Montenegro. In 2008, there was a decision explained by The Hague. There was a different approach, and it should be elaborated in detail. The Srebrenica, the massacre of 11,000 Muslims, there was an event, and since 1991, these events were raised, and they were reflected in the United Nations, and against Serbia there were some decisions taken. However, International Court of Justice did not evaluate it in full, and only in terms of Srebrenica there was a decision on genocide, and the decision was taken. However, since 1991, in Serbia and in each region of Serbia, against Muslims, there were oppressions on Muslims, and there were detailed reports on that oppressions, but it did not evaluate those reports. Moreover, the state of Serbia did not take it into consideration. It's important for them not to take it into consideration. And in the International Court of Justice, the preventive measures taken by Serbia were not implemented, but it was not, as I said before, taken into consideration by the International Court of Justice. And in addition, thousands of people were killed. Although thousands of people were killed, International Court of Justice, and there was no decision on compensation. And in terms of international law, especially Professor Thomas Short, it was debated, it was criticized a lot. This Srebrenica, and I even go beyond, and I can say that in the event that if a person joins the Srebrenica massacre, he has an individual responsibility, and by another international court, International Penal Court, if there is no such decision by International Court, then International Court of Justice may not have rendered a decision on Srebrenica. They were all important subjects, but they were not evaluated, they were not assessed enough in detail. And they were mostly elaborating on compensation, but there were, of course, more important things than the compensation, because they have weak justifications, and they were not, actually, they were not enough to be convincing. To be convincing, all the oppression, all the pressures should be listed, should be, fully pictured, and it was a huge neglect not to do it. And since it is not done, for compensation, it was not elaborated in detail. And again, there is another issue of implementation. International Court of Justice has another decisions, especially
İtalya'da mesela
In Italy, for instance,
Almanlar tarafında yapılan
there were some massacres and oppressions executed, perpetrated by Germany, and the Italian courts gave some decisions, and then International Court of Justice was referred, and there was an application to International Court of Justice. However, the judicial,
yargı sorumluluğu
I mean, there is no there is an immunity of the state. It was a justification, and it was declined. It was rejected. And similarly, there was another decision, Strasbourg Human Rights Court of Human Rights.
Almanya ile ilgili olan
This time about Germany,
kısal sorumluluğu olmadığı, muafiyeti olduğu nedeniyle
because of the immunity they have, there was a short decision, and then it was rejected.
şimdi bunlara bakıldığı zaman
Now, when you look at all those decisions,
gerçekten bu soykırım iddialarının
these allegations, genocide allegations,
sürülmesini
are put for, are not, it's not possible to put forward them easily, and the decisions
konuların kapatılması, sonlandırılması gibi
are taken to conclude the subjects as soon as possible, and the investigations are not done in due manner. And for the time being, of course, and some other decisions might be crucial.
iki karar daha var.
For example, there are two more decisions
Bununla ilgili değil.
about, it's not about genocide, but Shirato decision with Azerbaijan,
Ermenistan aleyhindeki
and against Armenia. There was an application of Azerbaijan against Armenia. There was an application, and European Court of Human Rights in the 70, in the page number 70, 700,000 Azerbaijani people were actually relocated, were deported. It was mentioned, but about this subject, there was no criticism. I did not encounter any criticism on this issue. You have 2 minutes. Okay, I will conclude my presentation, all right. And another decision that is available is the Perinçek decision. It's a very significant decision. And there, only the courts, there was no jurisdiction to judge the genocide. But it was important. But there is an important aspect of that decision. And this is, I think it's useful to examine it, but beyond this decision, there are important findings in that decision. Because as a defendant state, many states actually accept the Armenian genocide and the so-called Armenian genocide, but the Strasbourg court did not accept it. They are only the verdicts, decisions having the political aspects. Thank you very much. Thank you very much, Deniz Akçay, for sharing a vast information, and with your past experience, it was a very detailed, very comprehensive presentation. Thank you very much once again.
And now I will make a presentation that may seem out of the program, but it was a bit later, and it's about a more different topic. It will be about the abandoned properties and the legal problems in the current day. So it is a very detailed topic, actually a very specific one, and I don't want to take too much of your time. So I'll just touch upon the headlines, actually, the outlines, and I will just try to summarize everything. So maybe there may be some gaps in between. I would like to say I'm sorry for that as I begin. In our legal system, abandoned properties means the property left behind by Armenians who were dispatched or settled. And when I say property, I'm speaking about the assets, of course, but the estate, movable property are also included within this. And recently, in the international field, the properties left behind by the Greek are also trying to be included within the scope. So when we say abandoned property, in order for you to understand the problem, there are some important points that we need to highlight. First of all, we have a legislation on abandoned properties. There is also the Ottoman land law, and particularly recently, we have the Ottoman foundation law, which has gained significance recently. We have some cases that we are faced with, and these cases start to be heard by the courts of first instance, and if they cannot get the result they want, they go to the Constitutional Court, and also it can even lead up to the European Court of Human Rights. And the claims for property have become more prominent since 2012. The Armenian Catholicosate of Cilicia organized a meeting actually, and property had a separate session chapter on it, and they wanted this issue to be highlighted further, to put more emphasis on this, and they said the violations of property rights, in addition to violation of the freedom of religion and conscience, would create a bigger echo. So this is more like a strategy that they're pursuing. Of course, there are individual claims for violation of property rights, and back in 2016, the Constitutional Court resolved a case. It was this case is before the European Court of Human Rights right now, but particularly recently, religious institutions and foundations have been the focus in these cases that have been brought before the courts. And we have three important cases here. And these cases, particularly in the oncoming years, we believe we should work in a more detailed manner on these cases from the legal perspective. The first one is the Armenian Catholicosate of Cilicia. The second one is Sansarian Han Foundation case, and the case of Mayakop Armenian Church Foundation. So I'll just give you some brief information about these three cases. Let me start with the first case. The case, the lawsuit was brought to the court in 2015, referring to the centennial of the events of 1915. And what did they want to achieve? What outcome did they want? First of all, they go to the title deed directorate in Kozan, and they couldn't get a result, but without any other legal remedy, they just applied to the Constitutional Court straight away. And the Cilicia, Armenian Catholicosate Church, Monastery, and the other installments on them were asked to be returned, and an additional compensation was also requested. Also, they said that was a violation of the right to property, a violation of the freedom of religion and conscience, and also the justice was not served. This is what they said. But because the domestic remedies were not exhausted, this case was dismissed. Then in 2016, there was an application to the European Court of Human Rights, and the European Court of Human Rights dismissed the case because there domestic remedies had not been exhausted, and this was actually what was expected. But let me underline one fact, that there was no investigation into the nature of the property or whether there's a violation in terms of property rights or not. So first they said the domestic remedies should be exhausted. And then domesticos, in order to exhaust the domestic remedies, they applied to this second civil court of second degree in Kozan, and the hearings continue. The case has not been closed yet, and if they cannot get the result they want, I think they would then go to the Constitutional Court and the European Court of Human Rights. The second case, in 2011, there was the Saltzman Foundation case, which was brought before the court in 2011. And they wanted the registration of Sanasayan Han in the name of Sanasayan Han Foundation. It is an interesting case that I will be dwelling upon in a few minutes, and the prosecution continues actually, and it has even reached the Court of Cassation. And first of all, an expert report was created, and it was decided that it was actually a community foundation, and then they changed this decision that it was a community foundation, and later it was recognized as a fused foundation. The case is before the Constitutional Court now, and the third case is the case of Mayakop Armenian Church Foundation. This case is interesting in the sense that it is the case brought to court by an international foreign foundation. They want some immovables in Istanbul to be registered in their names. However, the prosecution continues in Ankara 15th Administrative Court, and the process continued at the level of the Constitutional Court. And there were claims that there was a violation of property rights and access to court. And then it was decided that there was a violation of the right to have access to court, and then it was referred to the first court again for prosecution. So the issue of the violation of property right has not been dealt with yet, because the case has not been handled from that perspective. So speaking about these cases, let me underline a few legal points. First of all, the abandoned property legislation. The first step was as a result of the decision of Council of Ministers in May 30th, 1915, when in 1915 there was a statute that was issued, and then there were also the ordinance that was issued, and the process continued. Some legal regulations were made. Then in 1928, two laws were enacted, which finalized the abandoned property legislation. And there is also information about the Ottoman land law, which may be of relevance. Before 1926, October 4th, and until the enactment of the civil law, there are references to the Ottoman law. And in the court, before 1926, when there is a case about the foundations established before 1926, the Ottoman foundation law is taken into consideration, and it is referred to. So about the Ottoman land law, what I can say is that as a result of the general land legislation or law of the Ottoman, we have these national lands which belong to the state in terms of ownership, but the tenure belongs to individuals. And these are national lands, just like in the case of the Armenian Catholicosate of Cilicia, the churches, the monasteries they are used by these religious institutions, but the ownership belongs to the state. So they only have the tenure. They are like tenants on that land, according to Ottoman law. Ebu Suud Efendi actually is an important jurist, Ottoman jurist. In his fatwas and similar other fatwas, it is said that churches and monasteries cannot be owned or cannot be turned, no churches can be established on that land where there's a church or a monastery. Another important point here I would particularly like to stress, because it has been popular on the agenda recently, and I think it will continue to be so, particularly when the judiciary is making a decision and when the academicians are carrying out their studies. There is actually a misleading fact that a wrong presumption that like all non-Muslim foundations are community foundations, but this is very wrong considering from the perspective of Ottoman law. In the Ottoman state, there were Muslims and non-Muslims who had the right to own charity foundations. They had the chance to establish charity foundations, just like Muslims. And just like the Sanatarian Han Foundation case, because it was actually a charity foundation in terms of its purpose, we have these types of foundations among the non-Muslim population as well. But foundations for or in the name of churches or monasteries is not allowed. And in the Sanatarian Foundation, it is a foundation that was established for the poor children to support them. So it is not just the community foundations. And the community foundations, according to the Lausanne Treaty, Article 43, and also in line with the foundations law, this type of foundation came into being in the Republican era. However, in the Ottoman era, these monasteries, churches, other religious institutions did not have, and synagogues actually did not have a legal entity, and they could not be passed on, and these are not actually registered in the name of individuals, and these can only be registered on saints and similar people, not ordinary individuals. And in Ottoman era, there was such a regulation, and there was a law which stated that from now on, the religious institutions can own foundations or immovable property. And then under the Lausanne Treaty, similar articles were there, and then in the foundations law, it was also provided for, and these religious institutions were asked to submit a declaration of the properties they had on their territory, on their land in 1936. And when you see a community foundation, they have their own estate, they can ask for the return of their estate, and they can manage their own estate. However, in terms of the fused foundations, which were inherited from the Ottoman era, they are subject to the foundations law. However, in these cases, which even go up to the European Court of Human Rights, actually, and this is a case, an incident that happened 100 years ago. So there are two criteria that are considered by the European Court of Human Rights. There should be continued violation, ongoing violation, and the second important point is that in addition to ongoing violation, there should be a real violation of the right of property, and there should be a reasonable expectation that was created as a result of this. And in our petitions that we give to the Constitutional Court or the European Court of Human Rights, we see that in all cases these 2 points are being underlined. And under the Lausanne Treaty and under the Foundations Law, there should be a reasonable expectation, and so in cases related to ownership of property, the Ottoman law and the abandoned property law legislation should be taken into consideration. It should be referred to. Thank you very much for your attention. So in our remaining time, maybe we can have a few questions. I will ask our speakers a few questions. We have lots of them actually. One of the questions I would like to ask to Deniz Akçay, this question. Raphael Lemkin in 1948, the UN Convention on Genocide, there is the definition of genocide, and they say it was inspired by the events of 1915, and during the convention, the preparation of the convention, was there in a referral to the Armenians. Mrs. Deniz Akçay, the floor is yours.
Gül Hocam sizin de mikrofonunuz kapalı şu an.
Mikrofonunuzu açar mısınız Sayın Deniz Akçay?
Your mic is off, Deniz Akçay. Can you turn it on?
Teşekkür ederim.
Thank you. I don't have any knowledge, any information about this, so I cannot comment on this, sorry. Yes, I certainly have no information on this. Probably it was used, but I don't think I can say anything about this without seeing the official reports or the minutes. Now, David Saltzman, there are some questions for you. I mean, lots of them actually. Here, one of the questions about the continued state in the international law. Are there any criteria internationally in the international law? So what are the criteria for the continuing state in international law? Or successor state, I can say.
Well, thank you very much for the question. Generally speaking, there are criteria, but they are mostly academic. So if we talk about what criteria exist within international law, my thesis is that there are academic indicators and theories, but that ultimately the law is state sovereignty. Once you are recognized as a state, you have the sovereignty to decide which obligations you accept and which you do not, irrespective of whether you consider yourself the continuing state or the successor state. When I say this thesis, I realize I am going against a lot of legal academic opinion, but I have read most of the legal academic work on this subject, and my belief is that it is insufficient from which to draw any rules.
Teşekkürler. Bir soru daha sizlere.
One more question for you. The international community, has the international community accepted Turkey as a new state? What is the general opinion on this topic?
Well, that's a great question. One of my other points in the thesis is that other nations treat Turkey as they see fit transactionally at the moment, as it is convenient for them. And indeed, it's equally important how Turkey sees itself. So if Turkey sees itself as a continuing state, as it has from time to time, then it can assert rights under that status. However, if another state, a third state, wants to impose that name on Turkey, and impose legal obligations from it, they cannot do so. They can only do so from an academic sense. Again, I believe my thesis is, it's not radical, but I believe that the international law really does gravitate toward strong sovereignty. That is what happens when we resolve wars. That is what happens when we ratify the Lausanne Treaty and declare the Republic of Turkey.
Teşekkür ederiz. Sayın Deniz Akçay bir şey.
Thank you very much. Deniz Akçay, do you have a comment?
Buyurun.
Yes, the floor is yours, Deniz Akçay.
Sesi açarsanız lütfen.
Maybe you can turn on your mic first.
Evet, herhalde bir anlaşmazlık oldu. Tamam. Buyurun.
Halefiyet konusunda ve Osmanlı Devleti'nin halefiyeti
About succession and the succession of the Ottoman state.
dergisinde yayınlanan
In the Avim journal, I have a very lengthy article actually.
şunu söyleyebilirim.
And what I can tell you on that topic is that
Devlet olarak Türkiye Cumhuriyeti
the Republic of Turkey
yenilmiştir sonunda.
has been accepted as a new state
Osmanlı
finally. In the first years, because of the obligation to pay the Ottoman debt, there was the
devamı olduğunu ileri sürerek
Swiss banker
Osmanlı borcunun tamamını ödetmek
who had the intention to make us pay the whole debt inherited by the Ottoman state. However,
başından sonuna
the negotiations under the Lausanne Treaty, I have looked into them
Amerika
thoroughly,
devleti
and Japan, the USA, they have taken the floor and said that Turkey, the Republic of Turkey, is a new state. So they recognized it like that. Thank you. We have so many questions, but we are already 5 minutes delayed. So, and we answered 3 questions as it should be. So actually, there are more questions to Mr. Saltzman. If he had the time, we would of course ask them. There are questions to me as well about the cases, about property rights, and are there any other cases in the international courts apart from property cases they are asking. But my expertise, I specialize in cases of property rights, so I don't think I'm competent to give an answer to this, and I would like to apologize from those owners of the questions we didn't have a chance to answer. I would like to close this session now, and I would like to thank the Republic of Turkey Presidency's Directorate of Communications, and I would also like to thank the valuable colleagues who have been working very hard to make this conference happen. And I would also like to thank our distinguished speakers who made very valuable contributions. And my last round of thanks goes to the listeners, the participants who listened to us with great patience. I declare the session closed. Thank you.
Evet, değerli konuşmacılarımıza ve oturum
We
başkanımıza
would like to thank our moderator and the panelists for their valuable contributions. This is the end of the second session. We will have a short break right now, and the third session on the current reflections of the events of 1915 and the perspective for the future will begin at 3:30 in Turkish local time. Thank you.